Well, hi there, everybody. Thank you for joining us this afternoon. Good afternoon to everybody joining us from Ontario. If you're in BC or Alberta, good morning to you. I am Sephton Leibbrandt, and I am an employment lawyer associate with Samfiru Tumarkin LLP, and we are the employment lawyers. So thank you, everybody, for tuning in this afternoon. If you're in Ontario, or this morning, if you're located elsewhere. So we're, of course, going to be answering your questions during the next 30 minutes, all questions employment law. So thank you. Looking forward to answering all of your questions this afternoon. Just to kind of get the ball rolling here while we wait for some questions to roll into the chat. A number of issues, close to home. One that seems to be very, very prevalent and prominent lately is the ongoing trade war, unfortunately, between Canada and the United States. And we've just had some information that this is going to continue, of course, hitting us close to home here. If you're located, for instance, in the GTA, you're probably familiar with the steel manufacturing that occurs in Hamilton, Ontario. And it's our understanding that, fortunately, apparently, because of the trade war and the steel tariffs that Trump has imposed, ArcelorMittal, the operator of the steel wire drawing plant located in Hamilton, is intending potentially to remove 153 approximately positions from that plant and to close operations there in part or in whole very shortly. So, very unfortunate in the circumstances, completely unnecessary, of course, in terms of economically speaking, but an issue that unfortunately has come up and continues to come up more frequently as long as this kind of trade war unfortunately remains ongoing. So for those who may be potentially impacted, it's not clear yet whether those jobs are going to be potentially relocated in part to Montreal, or unfortunately those individuals will be laid off on a potentially a permanent basis. But of course, it brings us to an important question, and this is a question that many people are asking me. Nowadays, I get many calls from prospective clients, asking about what happens if I am terminated as a result of the ongoing trade war between Canada and the United States. What are my entitlements in that respect? Well, that is a very, very important question. And the good thing is that in most circumstances, if you are terminated because of the trade war in relation to that, and it's clearly it's restructuring or shortage of work or things of that nature, then it's what's called a without cause termination. And a without cause terminations, generally speaking, one is entitled to a significant severance package under what's called the common law. And the common law basically looks at a number of factors to determine a severance package, including age, years of service, one's position, up to potentially a maximum of 24 months or 2 years of severance there in the right circumstances. So, if you're terminated because of, unfortunately, the trade war, you're not without recourse, is the good thing. You're entitled probably to, a significant severance package. And that's why it's very important that, if you are terminated without cause as a result of economic reasons, you absolutely reach out to an employment lawyer like ourselves. For instance, you can even go on our website and use the pocket severance calculator just to find out potentially how much you may be entitled to, with some very, very basic information there, entirely anonymous, of course, to help you kind of figure out what your entitlements may be. But for the most part, it's generally significantly more than what the employer, potentially, initially offers you upon termination. For the most part, occasionally you'll see, a fair severance package, but it's quite rare. Generally speaking, the most of the severance packages that I see offered out of the door from the company are usually, grossly inadequate, unfortunately. So, go and use our severance calculator there. See about, just initially, what potentially you may be entitled to in that respect. And of course, if you want further information, definitely reach out to us. We have people standing by, all the time to take calls to find out, what exactly are your legal entitlements in a particular scenario. And again, as I mentioned, the common law, potentially up to 24 months or 2 years of severance in the right circumstances. And of course, it's all based on one's age, position, years of service, and things of that nature. With the age and the years of service being the two most prominent and important factors in that calculation, of course. So definitely reach out to us in that respect. I see now that we have some comments rolling in and questions rolling in, which is fantastic. So I'll jump to that for the moment. So it looks like Manuel from YouTube has asked, I work for a US-based company and things have been tense for us Canadian staff. What sort of rights do we have as cross-border employees? Right. So great question, Manuel. So as long as you are located in Canada, presumably in Ontario or BC, Alberta, the good thing is that Canadian law, the provincial law, and whatever jurisdiction you're located in, that applies. If you're Ontario, for instance, and it's a provincially regulated company, so basically anything other than telecommunications or banking or airports or things like that, anything other than that, effectively, or certain types of resource production, you are under the Employment Standards Act of Ontario and entitled to those Canadian protections, even though it's a U.S.-based company. Now, unfortunately, the issue becomes that U.S.-based companies, unfortunately, don't always appreciate the distinction between, their Canadian-based employees who have much, much greater legal rights and protections than their U.S.-based employees do, and they kind of tend to treat them all the same. So for instance, I see all the time, people getting terminated from U.S.-based companies, and the severance package they're offered says that they get nothing because they're what's called an at-will employee or employment at will. And so you understand, we don't have anything about employment at will in Canada. That doesn't exist as a concept here. So there's no circumstance effectively, unless it's you're terminated for cause or willful misconduct, where the company cannot pay you anything, not even your minimum entitlements under, for instance, the Employment Standards Act of Ontario. So the companies, oftentimes they forget that very critical distinction. And so I see severance packages that clearly were contemplated based on a U.S. employee and really have no relevance whatsoever to a Canadian employee. And so, generally speaking, the severance packages I see from U.S. companies are typically, unfortunately, very, very, grossly inadequate in comparison to, the counterparts from Canadian corporations who have a sort of better understanding of the laws that exist here in Canada and Ontario and other jurisdictions, for instance. So, you have much greater rights, probably, Emmanuel, than your U.S. counterparts, especially upon the termination of your employment, in that respect. So if you are unfortunately let go as a result of this circumstance, absolutely, number one, you can use our pocket severance calculator and type your information into there to figure out a rough estimate of how much you may be entitled to from a legal perspective. But certainly reach out to us at employmentlawyer.ca and connect with one of our staff so that we can get a more detailed assessment of your case or circumstances. Again, you may be entitled to a very substantial severance package from the company, regardless of the fact that it's U.S. based. On the order of, again, potentially up to 2 years of severance there with the right circumstances and factors. So definitely reach out to us in that respect. So thank you for that question. I see a bunch of other questions rolling into the chat now, so we're going to get to those in just a second. Okay, it looks like John from YouTube has asked, my employer is asking us to sign a new contract we haven't received them yet, but is there something we should be looking out for when we do? Is it better to have these, or is this a red flag? Yeah, so this is a relatively common occurrence and a great question, Don, because a new contract, and of course, it depends, how long you were with the company. But for instance, if your original contract you signed with them is now 10 years old, or if you don't even have a contract, for instance, in either event, under the previous contracts or implied contract, you're probably entitled to a severance package of common law. The company knows this, and the company is attempting to get you to sign off on a new contract, potentially to seriously reduce and restrict your legal entitlements upon termination. And probably what the company is intending to do here, if you're, for instance, located in Ontario, for instance, is to limit you to the minimum entitlements under the Employment Standards Act. And they may be offering you some kind of consideration, so money in exchange for signing a new contract. But generally speaking, if especially you're a long-term employee, the consideration you're probably being offered is maybe $500, $1,000, something like that. Nowhere near in comparison to the loss that you are experiencing basically by forfeiting your right to common law reasonable notice upon termination. You could be potentially giving up tens of thousands of dollars, hundreds of thousands of dollars, even depending on your circumstances, by signing, unfortunately, this new contract that the company has offered you. So in this circumstance, if you do get this new contract, you should definitely reach out to us at employmentlawyer.ca and have somebody review the contract for you to make sure that if there are serious issues in there and you're really seriously prejudicing yourself by signing that agreement, that you don't do so, number one, and you see about making some kind of alternate arrangement with the company. There's no legal obligation on you to sign a new employment agreement if you are a continuous employee on an indefinite term basis with the company. You may wish to sign a new employment agreement because you want to continue on there, but oftentimes this is simply a tactic by the company, unfortunately, to get you to sign something that is seriously prejudicing your legal rights and entitlements, and maybe costing you at the end of the day, tens upon tens of thousands of dollars, if not more. So, that's. And the review of that contract is definitely something that you want to have a lawyer to do, to look into, exactly the issues and go through it with you, because there's a lot of different things to look at in terms of determining, is a contract enforceable? Number one, is it reasonable? Number two, and other things of that nature. So certainly reach out to us in that respect. But a great question, because I hear this all the time. Employees been there for 10, 15 years. They sign a contract the last 2 years. The contract is enforceable, limits them to the ESA. There may be a big problem there potentially. And as a result, they could have had, 12, 15 months of notice, and they're stuck with the ESA minimums, which is, a few months at most in the circumstances. So, a big issue and a great question, certainly. So thank you for asking that. If you're just joining us here, we're at about 15 minutes in now. I am Sephton Leibbrandt, an employment lawyer and associate at Samfiru Tumarkin LLP, and we are here today answering your questions, all things employment law. So thank you, everybody, for joining us this afternoon. A bunch of other questions rolling in here, so I'll jump to those very shortly. But thank you, everybody, again for joining us at this great session this afternoon. So looks like a bunch of other ones here have rolled in. I see a question from YouTube. Looks like Drew has asked, I work in a labor job 5 days a week. My schedule changes daily, and we can work anywhere from 8 to 12 hours in a day. My employer has said that we do not qualify. Oh, and it seems to have cut off there. Okay. Well, maybe I'll ask a further question. It's about overtime or vacation pay because we do piecework. Right. So it really depends on how many hours you're actually working in the day, Drew. If you're, of course, working, the piecework, it is possible, of course, to get in excess of the typical hours, and it may be a different set of circumstances there where, potentially because of the piecework, your hours look inflated compared to what they actually are. So they're correct in the sense that, yes, piecework, it potentially can inflate your hours, and it's not, the same as continuous actual hours of work. So it really depends, are you, clocking in at certain times, and how many hours, are you clocked in for? So if you, clock in the morning and you're working in excess of, basically 44 hours a week at the end of the day, again, actually working the time at the employer's place of business, if that's where you typically work, then that's where the overtime threshold is triggered, not, with respect to piecework itself. It's all about, the hours you're actually clocked in for at the employer. And, typically employers have some kind of clocking, time management or tracking system. And that's really what determines, are you entitled to overtime pay or are you not? It's all about how much time you actually spend at the employer's premises. And that's where you get you get to potentially trigger the overtime threshold. So hopefully that helps to answer your question. A great question, because it's something that I've seen come up in the past, various times. It's kind of confusing, but it's all about, the hours you actually spend working and the time that you record. And in those circumstances, you're entitled to potentially to overtime pay if you're working in excess of the overtime threshold. So thank you for that question, Drew, and a great question. I see a bunch of other questions rolling in here. It looks like Lakin from YouTube has asked, if my contract contains a non-compete, how much should I be worried about trying to find a new job? So Lakin, an interesting question, a great question. So basically a couple of years ago in 2021, non-compete clauses were determined to be illegal, going forward in Ontario. So if you signed a contract, since basically, I think it's October 2021, going forward, then the non-compete in your contract is illegal and unenforceable and doesn't affect you whatsoever. If it was a non-compete that was signed prior to that date, so the contract predates 2021, it potentially could still be an enforceable non-compete, but probably very unlikely that a judge, nowadays, unless it was a very well structured and drafted non-compete, which they typically are not from what I see, probably a judge would not enforce that, nowadays. So to answer your question as it is, it's, potentially, if it's, pre-21 contract, it's certainly potentially a reason you could use, as a valid reason in terms of why you would be inhibited from looking for, subsequent work in the industry if the employer is refusing to waive that provision in your contract. And of course, you can always ask them if they will waive that provision, again, given that it's probably illegal nowadays and unenforceable. If they won't waive it and they're insisting on your compliance with it, it certainly helps your argument that, it's going to make it more difficult for you to find another comparable job if you're seriously restricted in your particular industry. So, hopefully that helps answer your question there. But it's certainly, if they won't waive it, it helps your case from a severance standpoint. Absolutely. If it's a post 2021 contract, then it's probably illegal and unenforceable regardless by the legislation. So it really is irrelevant in the circumstances. You can effectively ignore it if it's again post 2021. So if you have a further question, happy to answer it. But thank you for that. An interesting question. I see it happen once or now and again. Most employers nowadays have become smart enough to stop including the non-competes and things like that, or just to waive them in their existing contracts, because really they're not ever properly drafted, and they're really not something that's technically permissible nowadays in the law as it sits in Ontario, for instance. If you're located in other places, it may still be applicable, BC or Alberta, for instance, but in Ontario, certainly illegal since 2021. So employers are starting to get the hint that they shouldn't be including those things, because it's really just cause a lot of problems, and it doesn't help them in the circumstances either, as you correctly point out. So see some more questions roll in here. Looks like another question from YouTube from James. James asks, I work as a security supervisor. After 15 years, the site is shutting down. I've been informed that as of the end of April, I'll no longer have a job. I have been offered a severance. Am I owed one? Okay, so James, long and short of it is, you are probably entitled to, a significant severance package if you've been there for 15 years. If you're a supervisor, that, typically tends to increase your severance package the more kind of senior your position is. If you're a management, for instance, even a supervisor, the longer it's generally expected that it will take you to find alternate comparable work. And so, unless you've signed an enforceable contract that limits you to not the common law to less to the SA, for instance, if you're in Ontario, then only in that particular circumstance would you not be entitled to a significant severance package at common law. So definitely something to reach out to the firm for about in that respect. And of course, you can find our information on employmentlawyer.ca. We're happy to have a further look into that for you. To cross the T's and dot the I's, so to speak, to make sure that there isn't anything else affecting your entitlements here. And in fact, you are entitled to what would be a sizable severance package based on 15 years of service in a supervisory capacity with your employer. So thank you for the question there and for reaching out. More questions rolling here, which is fantastic. Looks like Mary Lynn from YouTube has asked, lately my work hours have been getting cut down significantly. I'm going to have to take a second job to make up the difference, but my contract says I'm not allowed to hold a second job. What can I do? Mary Lynn, I mean, on its face, this sounds like potentially you're in a constructive termination situation here. If it's, if your hours are being cut back so much that you're being forced to take another job effectively to make ends meet, that sounds to me like you probably reached the legal threshold to demonstrate a constructive termination of your employment. The current employer, which would trigger, generally speaking, a severance package, again, based on your age, years of service, and position there. So, for instance, you can look at our pocket severance calculator to kind of find out, anonymously how much you'd be entitled to in that respect based on your current factors and circumstances. But to answer your question, and what you should be looking for here is, a reduction basically in your pay from the company in excess of 20%. If it's less than that, 15%, you may still have an argument, but it's not as strong. 20% or more is a very clear and obvious circumstance of a constructive dismissal at law, which would typically trigger the payment of a severance package, to you. So this is definitely one where you're going to want to reach out to us. You can find our information, of course, employmentlawyer.ca, and get connected with one of our staff to kind of get you some more insight and feedback in terms of your situation, which you can, of course, do free of cost. So reach out to them and have them, and provide them your particular details so that we can have a further look into this. Because, on its face here, it sounds to me like you don't even need to really consider the issue with the contract about, can I take a second job or not, unless this is something you really wish to do. But it sounds like the employer may have already breached the contract, if your hours of work have been cut so substantially that, you're basically not having to get another job. It's not reasonable, not fair, obviously. And again, if this is like 20% plus reduction in pay, sounds like you'd be owed 50%. Okay. You've asked another question here. So at least 50%. Do I tell them they have fired me? How should I approach that? So I would probably hold off on telling them that they've terminated you or anything like that until you speak with one of us here at Samfiru Tumarkin to get a full assessment of your circumstances. But if it's 50%, that's a very clear and apparent circumstance of a constructive termination. Of course, we need to look at your contract and things like that to make sure that there's nothing else in there that would limit your legal entitlements. But once one of our lawyers, for instance, looks at that and has a view over it, we'll be able to confirm that this is a situation where ideally speaking, you're owed a severance package in accordance with the common law, again, based on your age, years of service, position, rate of pay from the company, and things of that nature. So no, I certainly wouldn't recommend telling them at the moment, of this circumstance. Speak to one of us here, and then we can get you, clear details and particulars on, okay, well, if this is a constructive termination, what are you actually entitled to from a legal standpoint, and then potentially assist you, to further and obtain that, correct severance package on your behalf there. So please reach out to us, because it sounds like that's a big no-no from the company's standpoint, and something that really needs to be addressed rather soon. So thank you for that question, Mary Lynn. And if you have any further questions, happy to answer it. If not, I'm going to move on. We have a few minutes left here. If you're just joining us, again, I'm Sephton Leibbrandt, an employment lawyer and associate at Samfiru Tumarkin LLP, and we are, of course, the employment lawyers answering your questions this afternoon during our Q&A. So a bunch of other questions rolling in here. Just going through them because we have some limited time. Okay, so it looks like another question from YouTube. Nessie has asked, my employer was told my department that we're going to be required to start a 24/7 on-call shift rotation for support desk tasks. They're going to pay a premium on the hourly rate, but can they just change the scope of the job like this and demand we all provide on-call availability? So yeah, I mean, that sounds to be rather extreme, Nessie. I mean, it depends what kind of hours, of course, you were working for before, but to have that kind of on-call circumstance, constantly, that is something that would seem to be a great issue potentially. I mean, a lot of this depends. I mean, if you're working 9 to 5 and now you're constantly on call, I mean, that does not sound to be reasonable to me. Of course, if they're paying you a premium for it, maybe you let it slide. But if you have other obligations, potentially, family, childcare obligations that really prevent you from doing that, then in this particular circumstance, you may begin to start having an argument for a constructive termination there. It really have to be on the circumstances, your personal circumstances that are preventing you from doing that on-call work or being available for that. Strictly speaking, it's probably a breach of your contract that you have with the employer if you've not previously agreed to that. But in my experience, the court wants to see something a little bit above and beyond just something like a breach of a contract. It seems, usually it's about some additional prejudice there to really, trigger the payment of a severance package when we're talking about a change to the scope of the work, the scope of the job, and not to very significant things like cutting somebody's pay by 50% or things of that nature. So in that particular circumstance, definitely something you're going to want to reach out to the firm about. Employmentlawyer.ca at the bottom there, as you can see, just popped up, because on this one, it's very well potentially the chance that you do have the makings of a constructive termination argument, but a lot of it would depend on your personal circumstances and factors that are inhibiting or preventing you from agreeing to that new provision of your employment there. So thank you very much for the question, Nessie. A great question, as they all have been this afternoon. So I think that's almost all of the questions that have come in. So this is fantastic. Thank you, everybody, for joining us this afternoon or morning if you are in BC or Alberta. Been a pleasure, as always, to answer your questions. Our next installment will be Thursday, June the 19th at 1 p.m. with my colleague, Haley Auger. So thank you, everybody, again, for joining us this afternoon, and I hope you have a fantastic rest of your day. If you enjoy what we do here and these live Q&A sessions, then please like and subscribe and join us again in the future. Thank you very much, everybody. Take care and have a good rest of your day.